Good afternoon, everybody, here at the Law and Crime Network. We have a jam-packed, and I'm telling you, a jam-packed afternoon for you. All right, and we're back live in the Mcstay family murders case out of California. Right now, a continuation of cross-examination of the defense forensic accountant. Before we take you live into court, I want to bring back in Ann and Roger. Let's talk about this case because, boy, it's been going on for a long time. And I'm just curious, Ann, if you think that we could be losing the jurors here.
Oh, absolutely. I was just thinking to myself, a forensic accountant again? I think that was like months ago we heard from somebody that was a forensic accountant, of course, for the prosecution. But it's like so long and so detailed and so slow. I think you can lose a jury, especially where, there's certain things like we've talked about before where they're saying the murders happened at the house, but there's no evidence they happened at the house. So they're taking on burdens in the prosecution they don't need to. They've got great circumstantial evidence in this case, including, the DNA, you've got the proximity of the cell phones to the graves, the motive, et cetera. I can go on and on. But yeah, bottom line, you can really lose a jury by going on for this length of time.
Okay, we're just listening to some testimony of a forensic accountant, a defense witness, being cross-examined by the prosecutor, Melissa Rodriguez. And the point of this defense witness was to try to prove that Mcstay and Merritt had a fluctuating bank account and that they constantly transferred money back and forth. You'll remember the prosecution's theory, their motive, they believe, for Charles Merritt killing Joseph Mcstay and his family is that email Joseph sent to Merritt saying he'd been overpaid him by $42K. And they also say that Merritt had a gambling problem. So the prosecutor, though, during this cross-examination, Ann, is getting quite testy with the witness.
Right, and I think that's a mistake. I mean, it's like, like snark fest. You don't go there, like you can cross-examine, but don't be cross, as they always say. And I also think, with this kind of testimony, to fight with an expert, unless you're more expert than that expert, be careful, because you can basically step into a situation that you don't want to be in the middle of.
Okay, it looks like the witness there is looking for a record as the judge questions him about some particulars of his accounting. That's quite unusual that you're getting a judge so involved in the case asking questions of the witness. But this judge, has actually done this really throughout this trial. And have you ever seen that before?
It's pretty rare. You're right. I mean, it's because basically why cross-examine a witness is the judge is going to fix the testimony, so to speak, to clarify. I mean, and that's how he sees his role. But it is unusual. He can do it. I don't think it should be encouraged. It's, basically trials are organized combat, civilized combat. And so, we're all advocates. And when someone comes in and just kind of takes the wind out of your sails or explains the evidence in a way that you hopefully have shown the jury, to look at it differently, I'm not really sure where that gets the process.
All right, let's throw it back to court because it looks like testimony has begun again. That's quite a feat. I didn't think we could ever find such a thorough forensic accountant, but I do think he's doing a pretty good job holding his own as the prosecutor tries to get him at every twist and turn. Ann, would you agree?
Absolutely, and I think of those three rules in cross-examination: be brief, be brilliant, be seated. Stop. Right?
She's not following those rules, Ann.
No, I remember Irving Younger way back on all the rules of cross-examination, his 10 rules. His main rule was sit down, shut up. That's what I'm.
Well, and you can end up really hurting your case if you don't know when to shut up. And I'm sorry, Ms. Rodriguez, prosecutor, I think that you might be learning that lesson the hard way. Okay, we have to take a quick break. We'll take you back inside this fascinating cross-examination when we return. This trial also having its fair share of sidebars as well as objections. Let's bring back in my guests, Ann Bremner and Roger Foley, both via Skype. And I want to take it to you. How do you think the prosecutor is doing in this cross-examination? And tell us what is happening so far.
Well, I don't think she's doing very well. I mean, she's trying to establish the theory of her case, but this is a witness that's not going to help her. And I think her demeanor, as we've said before, is pretty testy, and he's not testy. I mean, he's basically calm as a cucumber. He's what is he, the Michael Jordan, of expert witnesses? So, I just think sometimes you have to say, get some things from that witness and then talk about them in closing argument. Save those things for closing argument, those connections that you want to make with the jury, instead of asking this question, which is, we've heard her say, would that change your opinion? Would that change your testimony? He's not going to say yes. He's too smart for that, right? So I think so far, she's not gotten very far. And if she does have information to use, save it for closing.
Yeah, if we ever get to closings in this case. Okay, so while they're in sidebar in California, we have to sneak in a quick break, but stay with us because we are also going to take you back inside the Robert Kraft hearing that's scheduled to begin in any minute. So stay with us.